Hello students and welcome to the class of Standard 7, subject Civics. Today we are going to learn about the features of Indian Constitution presented by Sara Pereira. In the last two lessons, we studied how our Constitution was made. We studied its preamble and understood terms like sovereign, socialist, secular, democratic republic. The goals expressed in the preamble are the characteristic features of our constitution as well. Apart from these, the constitution also has other features. We shall try to understand these features in the present chapter. The first is federalism. One of the important features of our constitution is the federal system. In countries with large territories and huge populations, government is run by a federal system. Ruling a large territory from a single capital city is not only difficult but may also lead to the neglect of some far-flung areas. People residing there cannot participate in the affairs of the government. Therefore, governments function at two levels in a federation. The government at the center carries out tasks like defense of the entire country, foreign policy, establishing peace, etc. It is also called union government or federal government. It carries out the administration of the entire country. The government that oversees the administration of the region that we live in is called state government. It looks after the administration of a particular state. For example, Government of Maharashtra looks after the administration of the state of Maharashtra. The system of running the administration of a country cooperatively by the governments at two levels, making laws about different subjects, is called federalism. So if by now it must have been clear to you all what federalism is. Okay, federalism is government working at two levels. Okay, we have a government which is working at the national level, which we also called as union government, and the government which is working at the state level, which we call as state level. And this is very important to have a federal system of government, because usually people always want their needs, their demands to be heard. If a government functions on the national level, then it becomes very difficult for a single government to look after every uh, every different state and look after their problems, find solutions to them. And so many states, they may feel neglected, they may feel ignored, or their demands may sometimes not reach to the government at all, and sometimes their demands may not be fulfilled. So then it can also lead to national problems or national conflicts. So it is always better to have two governments functioning at two levels. So when on state level there is a government, people usually have common problems, or whatever issues are there, they get sorted out on the state level itself rather than taking it every time to the national level. And this system is called as federalism. It helps in the smooth functioning of the country. The whole country functions well. Also, whatever decisions, whatever main issues are there, they are taken by the national government, and whatever is decided on the national level is passed on to the state level. So this is how both are functioning together. Okay, they are both working hand in hand. Okay, it is not that state level and national level governments are two different bodies. No, they work separately, but they work in cooperation or collaboration with each other. Separation of powers. The Constitution has divided the subjects for making laws between the Union government and the state governments. Let us see which government is entrusted with what subjects. Our Constitution has given three lists of various subjects. The first list is called Union List. It contains 97 subjects on which the Union government makes laws. The state government is for the state governments to legislate upon. It contains 66 subjects. Apart from these two lists, there is a concurrent list which contains 47 subjects. Both governments can make laws on subjects included in this list. If a subject comes up that is not included in any of the lists, the Union government is entitled to make laws on it. These powers are termed as residuary powers. The division of powers in the Indian Constitution is unique. It enables the Union government and the state government to bring about the country's progress by cooperating with each other. This also encourages participation of citizens in the administration of the country. Look into the image and we will understand who deals with what subjects. Union list. Central government has power to make laws and take decisions on the topics which are about defense, foreign relations, war and peace, currency, international trade, communication, etc. State government. State list. The state government has power to make laws on the subjects like police, trade, agriculture, irrigation, law and order, local government, health, prison administration, etc. Concurrent list. Both the central and state government jointly makes laws on the topics like education, forest, trade, marriage, adoption, succession, employment, environment, economic and social planning, personal law, education, etc. So this is how the powers or the authorities are divided separately, and there are some topics on which both the state and the union government can make laws, and this is how the functioning of the country takes place in a federal system. Union territories of India. In India, there is a union government, 29 state governments and 7 union territories. The union government controls the union territories. Following are the 7 union territories: New Delhi, Daman and Diu, Puducherry, Chandigarh, Dadra and Nagar Haveli, Andaman and Nicobar Islands, and Lakshadweep. Now, this what is there in the textbook is 2 or 3 years ago this was printed. Now it has changed where Jammu and Kashmir is also added in the Union Territory. So the list has changed, and the Union territories are administered by the Union government. Okay, Union government is nothing but the central government. So whatever decisions have to be taken or whatever administrative policies have to be made for these particular states are done by the central government directly. They come directly under the central government. They don't have their separate political bodies. They don't have their separate state level government. And so whenever any difficulty, whenever any problem, any issue, they are directly dealt with by the central government or the union government. And so these territories which come directly under the union government are therefore called as union territories. They belong to the state, the whole nation. They belong to the whole country. Okay, they don't have their own government. That is why they are called as union territories. Parliamentary system of government. The Indian Constitution has provided for a parliamentary system of government. In such a system, the parliament, that is, the legislature, has the highest decision making power. Indian parliament includes the president, Lok Sabha or the House of the People, and the Rajya Sabha or the Council of States. The Council of Ministers that runs the administration emerges from the Lok Sabha and is answerable to the Lok Sabha for all its decisions. In parliamentary democracy, the decision and debates that take place in the parliament have great significance. You must have watched it on television or on Doordarshan. Usually, we get to see this parliamentary meetings where all the ministers they come together, and these meetings are conducted on two levels. One is Lok Sabha and one is Rajya Sabha. Lok Sabha is on the state level where the ministers come together. Okay, they discuss on a particular point, they debate on particular point, and to make any decision or to formulate any decision they have to come together, and it is not always that they will agree with all the points. So usually when we watch it on television we see that there is a lot of fighting, quarrel, and agreement or disagreement on any point that comes up. And this is on the state level. Another parliamentary functioning is called the Rajya Sabha, where we have the president, the prime minister, all the ministers functioning on different levels, and they all also are sometimes opposed by the opposing party. And the opposition is not what I want to focus on, but the functioning, that why do they come together in this in this kind of meetings like Rajya Sabha and Lok Sabha. Okay, when they come together, they discuss on points that are concerning the nation. They discuss on issues that are uh, to be that need to be taken into consideration, and then there are questions asked to the ruling party that why these problems are not solved, and then they are responsible for giving answers. So when we have this kind of parliamentary system, there we have a give and take of ideas, we have give and take of uh, solutions, and also everybody or every minister is answerable. Every minister is asked questions for the work that he has done, and the work that he has failed to do, and he is answerable to the rest of the ministers sitting there. So this is how there is transparency in the functioning of the administration or in the functioning of government. There is transparency, they cannot hide anything from the people, and it is also shown on television so that everybody gets to see. And who usually presides this meeting is the decision is under the legislature. Okay, there are people who are appointed for it, there are people who take decision, they listen to all the arguments, and then they take decisions. So this is how the Indian parliamentary system functions. And this parliamentary system is very important to have a proper functioning of the country, where we live in a democratic country. Okay, it is by the people, of the people, and for the people. So the people also get their questions answered. Independent judiciary. The Indian constitution has created an independent judiciary. The disputes that cannot be resolved mutually are referred to the judiciary. Mutually is by verbal means, okay, where two parties who are having any dispute or who are having any problems, they can come together, they can discuss, they can try to find solutions, and they can agree on any particular point. This is a type of mutual understanding. But where, in whichever situations this mutual understanding does not happen, such cases are referred to the judiciary. Judiciary is the whole system where there are judges and where there are lawyers, and where this court system takes place. The court hears both the contesting parties, looks into the injustice if any, and gives its judgment. This has to be done impartially. Obviously, when a judge is sitting on his seat, he has to be impartial. He has to listen to both the arguments correctly. He has to be unbiased, and he has to listen if there is any kind of injustice done in that situation. And whatever decision, whatever verdict is given by him has to be impartial. No injustice can be done in the judiciary system. The Constitution has made several provisions to ensure that the judiciary remains more and more independent, because if there is any kind of force, uh, be it political force or be it any kind of superior power trying to put force on the judiciary, then the judicial system cannot function smoothly. Okay, then they will be influenced by others, and the decisions that are given will be partial. So it is seen that the judicial system functions independently. For example, judges are appointed by the president and not by the government. It is not easy to remove the judges from their office. Okay, a judge is a very important person. He is the one who has to give the decisions. And if he gives any wrong decision, any wrong verdict, then it can affect the life of the person who is victimized there. So it is a very big responsibility that a judge has to follow. And so he has to be independent, he has to be free from any kind of burden or any kind of pressure, like political pressures and all. So the judges are not appointed by the government of that particular state. If he is appointed by this state government, then any state related issue is there, then every time he will have to listen to the government, and he will have to listen to the person who has appointed him. So it is again kind of a pressure. So in this case, the judges are appointed direct by the president of the country. Okay, so when this is done, uh, the judges can be free to function, and they will be not under any kind of pressure or any kind of burden. So it becomes easy also for the judges to function. Otherwise, then their job or whatever duty they are fulfilling is of no use. Single citizenship. The Indian Constitution has granted a single citizenship to all Indians, that is, Indian citizenship. Okay, we all are one citizens, and here this also means that one single citizen cannot hold citizenship to two different countries. For example, he cannot be an American and an Indian at the same time. Okay, we have single citizenship. And this also focuses on a major concept like every citizen is equal. We all are citizens, which means that nobody is of higher grade or lower grade, nobody is inferior, nobody is superior. Okay, there is no point where there can be any kind of discrimination, because we all share the same citizenship and we all are the citizens of the same nation. So this single citizenship is a very important feature of the Indian constitution, where every citizen enjoys equal rights, every citizen gets equality, and they are barred from discrimination. Okay, they enjoy the wealth of the nation equally, and this is how in the functioning of the country this is a very important feature. Process of amending the constitution. There comes up a need to make changes or amendments in the provisions of the constitution due to changing circumstances. Okay, this is obvious because the constitution was made in 1950, okay, 1949, 1950, and the scenario at that time was different. Okay, the people who made the constitution, they have all died and gone. The situations of our country after independence were different, and now after many years the situations are changing. So whatever constitutional remedies or whatever points were included in the constitution that time may not always apply today. So it becomes necessary sometimes to change certain rules, change certain policies, and that change that is made is called as amendment. Okay, that change is called as amendment, and frequent amendments to the constitution may lead to a situation of instability. Okay, it is not that every now and then the constitution is changed or amended, because this will lead to instability. Okay, then every new political party that comes up, or every new leader, every new minister will come and he will go on changing the policies that are there in the constitution. So this is not how it happens. The changing of the constitution or the amendment of the constitution also has to go through a long process. Okay, it is not an easy thing, or nobody can easily come and do it. It has to go through process. The procedure for amendment is specified in the constitution itself, so as to ensure that an amendment is made only after giving it a careful consideration. Okay, when the constitution was made, that time only it was realized that maybe in future the constitution may need amendment. So whatever procedure is there was already mentioned in the constitution only, and so this amendment has to go through that procedure. Nobody can change that procedure also. Okay, and first of all it has to be given careful consideration. The procedure for amendment in the Constitution is unique. It is neither too difficult nor too easy. More scope has been provided for giving more consideration and thought to important amendments. Okay, a lot of discussion has to be taken into has to be carried out. Okay, many meetings will be. This will not happen in just one meeting or just one discussion. This is a long process, though it is not too difficult and not too easy, but it is still a very important process. Okay, so it is for the nation, it is not about one or two people. So that's why it is necessary that a good discussion is taken, a good discussion is done. Okay, proper consideration, proper giving thought to it, all has to be done. And the procedure is also flexible to ensure that general amendments can be brought about easily. Okay, it is flexible. It can be changed. Okay, it is not that no decision will remain the same. Okay, it is flexible, we can make changes. So this is how the amendment of the constitution is done. It goes through certain processes, and these processes are already given in the constitution, and when a proper consideration, proper discussions are made, a rule or a policy in the constitution can be amended or can be changed. Election Commission. You must have read about the Election Commission in the newspapers. Since India has adopted a democratic form of government, people have to elect their representatives periodically. For this, the elections have to be conducted in a free and fair atmosphere. Okay, every now and then we hear about elections, and there are elections done to select the representatives of different states, different sections, and these elections take place at a fixed interval of time. And for every election to be conducted, it is very necessary that the elections have to be conducted in a free and fair atmosphere, because it is ultimately the question of nation or question of the national security also. Only then will the citizens be able to elect a candidate of their choice without any fear or pressure. We know what kind of things take place when elections are to be conducted. Okay, many people, they follow unfair or foul means to collect votes from the people. They force the people, they give some kind of bribe or some kind of gifts to the people, so that people vote in return. Okay, so this is not a fair policy, this is not a fair election, because this is injustice. People, if they want to elect somebody freely, then they're not able to do so, because they are pressurized by the political parties, they are pressurized by the higher authorities. And so there is this election commission. If the government were to conduct elections, there might be no guarantee of such free, fair, and just atmosphere for the elections, because we know that in every state the government is of one political party, okay, of a particular party. So when there are elections to be conducted, if the elections are to be conducted by that government, state government, then they will obviously focus on gaining more votes for their political party. And then there will be injustice, there will be partiality, and there will be more influence, more dominance, and this will not be a fair judgment. And so, hence, the Constitution has entrusted the responsibility of conducting elections to an independent machinery. Machinery is nothing but a different body, a separate committee. Okay, this machinery is known as the Election Commission. The responsibility of conducting all elections in India rests with the Election Commission. Whatever elections take place in our country, whenever these elections take place, it is done by the Election Commission only, and the Election Commission is responsible for conducting the elections so that they ensure that there is a smooth functioning, there is no partiality done, and everything that is done with um, a lot of clarity and in a proper way. Okay, so this is the reason why election commission is held, and the responsibility of conducting all the elections in India rests with the election commission. So this commission is not only looking after the elections of one particular state, but the whole nation's elections, whether how the elections will be conducted, when the elections will be conducted, then the counting of the votes, the declaring of the result, everything is done by this election commission. The Indian constitution has some important characteristic features. In this chapter, we have studied only some of the important features. Another important feature of our constitution is the exhaustive provision of fundamental rights. We shall study these in the next chapter. Thank you for giving a patient ear.